The task of the CCJ is of a similar vein, and it matters not that Marbury may not have been taken under its appellate jurisdiction. In fact, Marbury was supposed to be a case under the original jurisdiction of the Supreme Court. Marbury was nonetheless, even under its original jurisdiction, and this is a point, as Professor Anderson pointed out, which is critical here. Even under its, the fact that Marbury was an opinion essentially or technically under the original jurisdiction of the Supreme Court, it was nonetheless the utterance of the authoritative voice of the Supreme Court of the United States. That is critical. That is why the appellate jurisdiction of the Caribbean Court of Justice is so essential. Thus, the strength of the analogy between the CCJ and the US Supreme Court rests on the fact that whether it be in the exercise of its original jurisdiction to interpret and enforce the revised Treaty of Chaguaramas, or in the exercise of its appellate jurisdiction interpreting the constitutions and laws of the member states of the Caribbean community, the CCJ would nonetheless be engaged in the construction of the meaning of the law of the community, and all of his judicial opinions would necessarily constitute an essential part of the political narratives of our people. It therefore bears emphasis that there can be no radical disjunction between the court's exercise of its original jurisdiction interpreting the revised treaty and the court's exercise of its appellate jurisdiction interpreting our constitutions and laws. In either respect, the Caribbean Court carries the urgent and profound responsibility for the inscription of Caribbean nationhood. The question then of the establishment of the court as a final court of appeal for the Commonwealth Caribbean has therefore to be one of the most critical issues in constitutional reform. It is simply a matter of completing the process of constitutional founding and of defining the sovereignty of our sovereign states left unconcluded at the moment of political independence. Put simply, the establishment of our regional court is an act of self-realization and fulfillment of our sovereign will, an act of self-definition and of inscription of our Caribbean nationhood. For it is a fundamental understanding in modern political theory that adjudication is an integral and inextricable aspect of sovereignty, one of the essential competences of a sovereign state. And it is in the act of adjudication, in the interpretation and application of the Constitution, in the determination of cases, that the Constitution itself is given meaning and reality in the life of the polity. It is in the act of adjudication, in the writing of judicial opinion, that the process of the completion of the Constitution is advanced and the polity defined, that a people's authorship of their own fundamental law and the inscription of the sovereignty are signified. In other words, the critical importance of the CCJ to the public life of the region would become evident when we consider the broader cultural task of adjudication in drawing and defining the proper relationship between our constitutions and our central political texts and West Indian society. That is, in defining the social role of the Constitution, of our constitutions, how they shape our society as they are made to respond to the interests and claims of the West Indian people. For the foregoing reasons, among others, we have noted that the single most important fact distinguishing the Caribbean Court of Justice from the British institution, the Privy Council, is that the court is an institution of our own making. As such, as we've said, the court carries an authenticity that the Privy Council simply cannot claim. The significance of this very critical point is made more evident when we reflect on what is entailed in constitutional adjudication and how that complements with what have begun with political independence. Moreover, it bears remarking that the choice of the Privy Council as our final court of appeal at the time of political independence was hardly an act of sovereign will, for no sovereign people willingly relinquishes such an essential aspect of the sovereignty unless compelled by circumstances to do so. Rather, our choice of the Privy Council as our final court of appeal was an act of political necessity. We simply did not have the means of political will to establish our own final court of appeal. Now, some 30 to 40 years later, we have come to the realization that this anomaly must be corrected. Hence the significance of this issue for constitutional reform. So whether in the exercise of its appellate jurisdiction, interpreting and implementing our constitutions, our laws, and the revised Treaty of Chaguaramas, establishing the Caribbean single market. The CCJ carries a cultural and political identity that the British court could never claim. It is a genuine representative institution of the West Indian people, with the authority to speak in their name. That is to say, its judicial voice, whether in the interpretation of the revised Treaty of Chaguaramas, to give text and life to the words of the treaty, or the interpretation of our constitutions and laws, the opinion of the court would appear as the voice of the West Indian people. In this respect, the court functions as a central institution of regional governance and integration, its judicial opinions constituting the core political narratives of the West Indian people in their attempt to define and maintain themselves as a single political subject. Put differently, my thesis is that in adjudication, whether under its original or its appellate jurisdiction, the Caribbean court would be engaged in the performative act of reading and narrating the West Indian polity. And therefore, unlike the Judicial Committee of Her Majesty's Privy Council in England, the Caribbean Court of Justice, legitimated as a creature of the Caribbean community, would inevitably be engaged in performative acts of self-definition. The significance of this can hardly be overstated, for the establishment of the court and the Caribbean single market and economy is articulated against our apprehension of ourselves as a sovereign people, of a similitude of circumstance bound together by a common conviction, a kindred consciousness of an inward necessity to constitute and define ourselves as a single political subject for our social, political, and economic development. The idea is not to assume away our plurality, our rich cultural diversities. Rather, it is to lay hold of certain commonalities, our occupation of a certain geographic space, sharing certain common historical and political experiences, engaged in a common enterprise of constituting ourselves within a single economic space that is most conducive to our prosperity and growth. On this view, the court, with jurisdiction to interpret and enforce the revised Treaty of Chaguaramas, establishing the single market and economy, and also to interpret and enforce the constitutions and laws, inevitably becomes an indispensable instrument of regional governance and integration. For, as we have earlier stated, the CSME represents an attempt by the Caribbean people to construct an economic space within which to facilitate a more efficient and productive engagement amongst ourselves, and to form a certain viable economic zone for our engagement with the global economy. It means then that the judicial decisions of the court interpreting the provisions of the treaty in cases are necessarily authoritative political text constituting forms of self-definition. Similarly, the judicial opinions of the court interpreting the constitutions of the member states of the Commonwealth Caribbean would comprise some of the most important and authoritative political texts, supplementing and defining the constitution themselves and the political order they constitute and recommend. We have earlier intimated that constitutional founding, the narrating of a polity in words, is an inscription of a people's political identity, that a people's authorship of their own fundamental law is an inscriptive act by which they purport to define themselves in a certain way. But the Constitution as a fundamental political text is notoriously incomplete, and it is not a self-interpreting or self-executing document. It is rather always in the process of being completed in the act of adjudication and supplemented by the judicial opinions. The authoritative political text issued by the nation's Supreme Court. The judges of a nation's Supreme Court, we have noted, are therefore numbered amongst those titled individuals who write a people's nationality and political identity. Those titled individuals who establish their founding political institutions, write the political texts, the poems, the novels, the historical essays, and paint the masterpieces. For us in the Commonwealth Caribbean, the judges of Her Majesty's Privy Council, amongst those titled individuals, compared to our Derek Walcotts, our Camille Braffitts, our George Lamings, our Dunstan Saint-Omer, who paint our masterpieces, define our nationality. The judges of Her Majesty's Judicial Committee are amongst those titled individuals who write some of our most important political texts that supplement our constitutions by which we are governed. They are therefore in a very real sense the authors of our fundamental law. The truth of this claim is readily established with a moment's reflection on the political significance of the Privy Council's decision in Pratt and Morgan, which was nothing less than a foundational constitutional interpretation, an interpretation that determined the meaning of a foundational constitutional provision for the entire Commonwealth Caribbean. As a result of this decision, we have noted, and to get around the strictures, countries like Jamaica, Trinidad and Tobago, and Barbados have either opted out of the optional protocol on civil and political rights, of which they were a part, or they have passed sweeping constitutional amendments. Ladies and gentlemen, the court, to repeat, is one of the principal instruments by which we would write our own jurisprudence, our nationality, and give meaning to our own political identity. It is also one of the principal agencies of regional integration through the harmonization of our constitutional law. The court therefore has the critical educational office of schooling the nation on constitutional meaning. And it, as I've said before, it discharges this most important adjudicative task, or educative task, I should say, through the interpretation of our constitutions and the inscription of some of our most authoritative political texts, supplementing our constitutional law. In that sense, ladies and gentlemen, there could be no more compelling case for our adoption of the CCJ in its appellate jurisdiction. Thank you.
Well, there you have it, ladies and gentlemen. We now open the floor for a few questions, brief questions. So come forward, there's a hand up there.
Hello, good evening. My name is Debbie Douglas. I'm from the island of Dominica. I listened to all the arguments tonight, and while I agree with your sentiments and your statement that the Caribbean have reached the stage where we should be able to adjudicate our own affairs and not have to resort to the Privy Council, many years ago, back in London, in 1995, I was a law student, and at the time there were jurists like yourself coming to the law schools and telling us why we need the CCJ, and I was one of the big mouths, main advocates for the CCJ. However, fast forward 10 years later, I have doubts. Why? Because I see that, our democracies are weak. There have been many instances where I have seen interference from the political government people as high up as ministers. I believe that when you're talking about the judicial system, especially one as ours that has been, by and large, with all our shortcomings, we've maintained strong democratic institutions in the Caribbean. I think that tradition should continue. When you have a situation where you have a prime minister interfering in the appointment of a justice from my own country, Dominica, because he ruled against him. We're not ready for the CCJ. I mean, these theoretical arguments are all right, in theory. But the reality is we're not Canada. We are weak democracies. Even the CSM itself is a work in the making. And we cannot, we cannot have a situation where our judicial system becomes almost like a rogue state like Zimbabwe, where you have all sorts of, because the fact is, whereas I have high regard for the Caribbean judiciary, people like yourself, I don't forward the political establishment, because a lot of people get into political office here based on being the most popular person in a village. And they simply lack the ethics and morals to maintain and uphold our institutions. If we go down the route of the CCJ right now, with all this kind of political meddling, and there are other instances which I won't mention, I don't want anyone to sue me, but you're aware of, I'm sure, because the islands are small and everyone knows who's doing what. We're going to go down a slippery slope of rogue states like Zimbabwe. And that's not good. You cannot have a situation where people are just going at the whim. They could do what they want, sleep with whoever, rape this and that.
I think I got your
and,
point.
And this is just a joke. I mean, we've got to address those. And you as the people who are engaged in the CCJ to wrap up, how do you address those and how do you put checks
Who do you
and
want to
balances?
answer the question?
I think I throw it out there to all of you. And let me say, I am a firm believer of Caribbean unity. My father,
I know, but we can't go on. You can't take it for
and
the
I
whole
support
time.
it. But my father, the late Prime
All
Minister
right,
of
okay.
Dominica, was a strong nationalist. So I am for
We've
it.
got your point,
But we
miss.
need to address these questions very seriously.
We've got your point. We've got. Wait, Ashley. Wait. Before you get. Let me say this. With all due respect to my colleague, Professor Anderson. Is this thing on? With all due respect, Miss, are you going to listen to my response now? Yes. With all due respect to my colleague, Professor Anderson, you have made a more compelling argument for the CCJ than we have made tonight. You have just made a more compelling argument. Because your starting premise, even though you spoilt it with the kind of polemical statements that you were making, your starting premise, I'm answering your question now. Your starting premise was to strengthen democracy. And the way in which the Caribbean Court of Justice has been established, and the points that we have been making here tonight with the detail in the technical issues, the attention to the detail for the independence of the court, would ensure that that court functions as that critical institution of democratic governance in the Caribbean. That is the point that you have just made. You have made a case for the CCJ. Thank you very much.
Sandra.
But I wanted to...
Oh, yes.
Okay.
Hold on. Sir, hold on.
Could I just make one small point, if I may? I think it's very significant that all that you have said seems to have taken place under the watch of the Privy Council. If you think about what you have said, about all of the illegalities and the undesirable things which have taken place, it seems to me that they have taken place under the watch of the Privy Council. Now compare that situation with Barbados, for example, which has abolished appeals to the Privy Council and which has accepted the Caribbean Court of Justice as its ultimate court. I don't see that Barbados has suffered as a result of that. The other point to make, of course, is that there are very stringent provisions in place for the appointment of judges to the CCJ. And those provisions do not allow for the interference by politicians. We could go through and name the institutions which are responsible for appointing the judges. Those institutions are not comprised of our politicians. And that, I think, compares very favorably with the arrangements in other jurisdictions, including in the United Kingdom.
Yes, good evening. First of all, before I say what I want to say, I just want to make an observation of Dr. Anderson's response. And that is, you know, Barbados is not typical of the rest of the region. And Barbados has had how many years of influence, including, you know, whatever. Now, I want to say, Professor McIntosh, that the spirit of your presentation, and I've heard your presentations before, they are consistent, they are passionate, and that spirit resonates with me. The philosophy and the ideology, recognizing the importance of people and the voice of the people. And it is interesting that you compare it with the American Constitution. And certainly, I am all for that. And I'm also happy that you made the point that it has to come from the people. So it is not some people in some legislature going and vote. I think that that is an absolute no-no. And I may want to make a very controversial observation here, which I wouldn't want to deviate from the rest of what this evening's discussion. And that is Grenada. Because, in fact, if we had not had our own process so tragically and unfortunately aborted, we might have been well on the way, or perhaps have already done it. But historians like Dr. Jacobs, you know, can talk more on that. Now, I certainly agree with the sister there from Dominica because the issue of governance is key in this region. And I'm very happy that you have given us those assurances this afternoon, this evening, because quite frankly, I am not so sure. I am really not so sure. And I trust that our generation of lawyers that you are responsible for putting out at UWI are very much aware of their responsibility for good governance in the region, for issues of ethics, conflict of interest, and governance, because that is where our judges are going to come from. Now, I want to make an observation about the CCJ, because I don't know if it is, again, if it speaks to the way of how we do governance and how we make decisions here, and if in fact we are debating after the fact, whether in fact a lot of this debate should have come before, so that we would have been very smoothly going into the process, and we would not have had to have an emissary coming to, you know, at a point in time, if this was last year, somebody might have asked, who sent you? You know, if you get my point. But the compelling arguments that you have put for the CCJ, for example, speaks to the ultimate sovereignty of the region. And you have said, well, Barbados hasn't suffered that and it has gone from the CCJ. So I don't know, because when you look at the other decisions that are going on and the wholesale sellout of the islands and all sorts of deals with crooks and conmen, I don't know if I could just say that CCJ is going to assure that. And if in fact, because CCJ has come into being as part of the context of globalization and liberalization, if in fact it's not going to facilitate that. I have a couple other comments, but I think I talk enough. I will rest my case there.
But just a second. I mean, but this is fantastic. I keep having to turn your arguments on its head. You are making arguments for the CCJ because, as my colleague has pointed out, all the bad things that you're describing are under the watchful eye of the Privy Council that you don't seem to want to get rid of. So the point I'm making is this: if in fact the CCJ is supposed to, well, please, if in fact the CCJ is supposed to be one of the key instruments of democratic governance in the region, then how is it that you're so doubtful about the CCJ, when in fact you're pointing to all these things that are not taking place under the watchful eye of the CCJ? They are not taking place on the watchful eye, as my colleague has pointed out. But in essence, what your argument is really is for call for strong democratic governance. And therefore, the CCJ is precisely that, an instrument of democratic governance.
Thank you very much. I'm Nande Trotman-Joseph, an attorney at law, and a very proud product of the University of the West Indies legal system. I'm homegrown and I was trained and I'm very proud of it.
Thank you.
Now, as a graduate of UE and a West Indian trained lawyer, I started off going on 23 years ago in a very idealistic way, believing in one Caribbean, believing in the core principles that have been talked about in the Treaty of Chaguaramas. Some 23 years on, I am a little jaded, I will admit. But not for some of the reasons that I'm hearing expressed before. My concerns are especially with the failure of our CARICOM governments to adopt the appellate jurisdiction of the Caribbean Court of Justice. I am one of the choir. I think I have been in the system and contributed locally and at the CARICOM level sufficiently to understand how necessary for that final completion of the circle of independence that we have been speaking about, it is for us to have the CCJ. I am jaded because perhaps our peoples at the levels of our societies, our communities, and as a CARICOM community, do not have the collective will to perhaps push or clamor of their political leaders for the appellate jurisdiction, because indeed, if it becomes a reality, some of the very concerns that we are hearing expressed tonight will be dealt with by that court. So my real concern as someone who has come through the ranks of civil society is that civil society perhaps has not been sensitized sufficiently by CARICOM, by the national governments, and perhaps the horse is already bolted. I hope it is not too late for emissaries such as yourself to convince persons, citizens of this region, that this court is necessary. Because even the turnout here this evening, perhaps it tells us a story that people are either complacent or they have no interest, or perhaps they just do not know what this whole process of our independence is all about. So perhaps when you go back as emissaries, back to CARICOM, I know Professor Anderson spent some time there, you need to tell those in authority and at every level that a lot more has to be done. We need to use our cultural vehicles, our media vehicles, and so on, our civil society organizations, to keep this message alive. This is the message of our hope as a people, a Caribbean people, our salvation as a Caribbean people. Just as how Sandra and myself, for example, speak about empowerment, rights, and so on. This is one of our rights, and it must be kept alive. But having said all of that, I want to quickly throw out as well that CARICOM has signed or agreed a charter of civil society many years ago, and there's been some talk of going a little further to something similar to the Banjul charter, or a more meaningful convention of our civil, political, socio-economic, and cultural rights. And in the absence of that development, I would throw to you whether the present appellate jurisdiction of the CCJ can deal with ensuring that these rights are in fact respected and further entrenched by the adjudicators in our CARICOM region.
You, Brian, you take it over. Brian, Dr. Bradford, then behind. Okay, Pastor, go ahead.
Yes, I wouldn't take a long time.
Try and be brief, okay?
Yeah, I wouldn't take a long time. First of all, I think it's unfortunate we have two major activities today. At the university, St. George's University, you have a lecture by somebody, a professor from the University of KwaZulu Natal, dealing with correcting the historical wrong in South Africa. So it's unfortunate. I think some people have gone down there. I would have liked to go down there myself, but I choose to come here. Also, I would want to find out if the presentation can be made available to people. I would like to read it and study it so that I could even do make some comment. And finally, I will say that I agree with most of the sentiment expressed here, but I also want to offer a dissenting view in the sense that I think we as a people need to hold politicians and others accountable and responsible for the dealing. I think many times we go to sleep. We need to have what I call the politics of engagement rather than consignment. Thank you very much.
Thank you.
Good evening. I'm not an attorney at law, and we are in the majority. Do I hear a different approach to selling the CCJ? And I tell you why I say that, because early in the game we were talking about, I think there was an argument about a decision by the Privy Council concerning the death penalty. I think there was another argument about referendums. But now I'm hearing a predominant argument about amendments to constitutions. And if that is so, then am I also hearing some harmonized approach to constitutional reform? Am I also hearing that we have to now consider all these things in our approach to the approval of the CCJ. Is this a new approach, Randy? You're reaching for the mic.
No, it's not a new approach in this sense. The thrust of my position is to offer philosophical justification for our having our own final court of appeal. That is, us in the Commonwealth of the Caribbean having our own final court of appeal. The question, given our various constitutions, the question as to how we go about ensuring that the court becomes part of our judicial system, as it is now part fully of both Barbados and Guyana's judicial systems. How we go about doing that has to be taken care of. And that is essentially the question as to whether we need a referendum in some places and in other places whether we don't. But separate and apart from the so-called technical issues as to how we delink from the Privy Council and join the Caribbean Court of Justice has to be, why? Why have your own final court of appeal? Why not just leave it with the Privy Council ad infinitum? Let them do it. Why? For example, some people might say the Privy Council could render better decisions in the sense that they're not living in the society. I've heard prominent lawyers say that, in the sense that they're so removed from the society that they render better decisions. What these lawyers don't say is that the very judges who decide our cases, they're also part of the House of Lords deciding British cases, but they're living in Britain. They're British citizens. So why is it that they're not away from Britain? In other words, do you see where I'm going? So the point I'm making is this. It's not a new argument. What essentially it is that for me, from my personal standpoint...
No, I didn't say a new argument, Randy. Bear with me a minute. I say a new approach.
Yes.
And that the old approach seemed to have confused us a little bit as far as the political influence was concerned. If you see where I'm going with this conversation. Now, if we're talking constitutional reform, and most of our islands in the past few years have been talking constitutional reform, are we now also not only talking about firing the CCJ, but firing the Queen?
Yes, we are. But let me do this. Let me do this. What I'm saying, therefore, is this. In essence, if you want to cast the problem in terms of constitutional reform, why do we want constitutional reform in the region? In other words, if constitutional reform is a noble endeavor, it has to be back to the points that were made about strengthening democratic governance. You don't want constitutional reform in order to destroy your democratic polity and put a dictatorship in place. You want constitutional reform to have better democratic governance. And I'm unapologetic that I don't care what systems some of us may venerate in the region. Constitutional democracy makes the strongest claim to political and moral legitimacy as a political system, not communist dictatorships. Constitutional democracy is a moral good. So I am unapologetic about that. Therefore, if we're going to have constitutional reform, it has to be for strengthened democratic governance. The point is that establishing your own court to ensure this end result of strengthened democratic governance is a critical aspect of constitutional reform.
So we're saying constitutional reform is urgent.
It's urgent.
My final comment, I noticed you referenced the American system quite often. Am I to understand or believe that sometime down the road, if not now, that people could be appointed to the CCJ by not necessarily being a lawyer, but in fact have good understanding to interpret the people's position? What do you say?
I am not sure.
As is now the argument in the United States on appointments to the final court of appeal, that you don't necessarily have to be a learned jurist.
No.
Oh,
no,
okay.
No.
I thought I saw you wiggling.
No.
Is that, just before Dr. Brathwaite, if I may, I just wanted two things. One is the question about the appellate jurisdiction on the rights. Now, of course, you're correct that there is a Charter of Civil Society adopted under the CARICOM aegis, but that charter is expressly not binding. And there are attempts to develop a convention on civil and political rights. And the efforts to develop that convention are ongoing. And I hope that that will bear fruit in due course. But note that in relation to the appellate jurisdiction, the judges in the CCJ will be interpreting the Bill of Rights in all of our constitutions. And all of our constitutions have basic rights which would be enforced in that way. In terms of how the judges are appointed, it's very important to emphasize that our politicians do not have a voice in the appointment of the judges. There is a body, the Regional Judicial and Legal Services Commission. It has on it representatives of the National Bar Associations, of the Regional Bar Association, of the law school. I think the dean has a hand in appointing members there. Civil society, non-lawyers also sit on that body to appoint the judges. The prime ministers, the ministers do not have any say at all in who becomes a judge at the CCJ. This is a matter taken entirely out of their hands, and I think that's a good guarantee of the independence of the judges. And of course, this body also has the power over the selection and the retirement, the discipline of the judges. So I think that makes for much more independence in our judges than the ordinary procedures would. And of course, there are special procedures for the financing of the court, as I mentioned, a trust fund, which has been established, which is beyond the recall of our governments. I think that helps to ensure the integrity and independence of the court.
Both you, Professor Anderson and Professor McIntosh, give very erudite presentations, and I think you're basically talking in most audiences, most West Indian people who understand their history, who understand especially where we are today with respect to international issues, are more than convinced that we need a Caribbean Court of Appeal. However, I think it is a question of confidence. Some of the speakers tonight raised some of the issues. One relates, of course, to potential political interference. But I suggest that it goes beyond that. And I say that because the courts are such a critical body. We have in life, in all parts, choices. Choice of your business place to go to, your medical service to go to, etc. But you only have one court to make judgments on you. And if that court potentially becomes corrupted, therein lies a great cause for concern. In 2008, or 2007, perhaps more so, we saw what happened in Trinidad and Tobago, right? I mean, that was a horrible episode in the hierarchy of the judicial services. In Bahamas, again, I believe there were queries about it. Back home here, we can allude to cases where less than ethical behavior took place at the highest levels. How are we to have confidence in the very judges themselves? I mean, I have great confidence in you and the majority, but I think you just said that that body will more or less look into and discipline itself. I may have got it wrong. And the question always is, as in most professions, who is going to guard the guards? Because this thing is too fundamental, too critical for us to get it wrong.
Yeah, well, no doubt Professor McIntosh will come in, but let me just say that at the moment, we have on the bench at the CCJ very eminent, distinguished men of integrity. And what is very unique, one of the things that's very unique about our arrangements is that the judges need not necessarily be Caribbean nationals. In fact, we could have some of the judges on the Privy Council sitting on the CCJ, because the terms of reference allows the Regional Judicial Legal Services Commission to appoint anybody from the Commonwealth world who, in the opinion of the Commission, satisfies the requirements for sitting on the bench. So we have a judge, for example, who is of the civil law extraction, Justice Witt, who comes out of Suriname or has connections with Suriname. We have Justice Hayton, who has no connections, as far as I am aware, with the Caribbean. He's an Englishman. We can have judges from any part of the world that we decide. And when I say we, I mean the Regional Judicial and Legal Services Commission. And that commission represents you and I, because we have on it, as I said, the bar associations, we have the law schools on it, we have non-governmental organizations on it. So these, all representatives, sit together in a body, and they decide who will sit as a judge on the CCJ. And they are responsible for the appointment of the judges, questions to do with their retirement, questions to do with their discipline. So I really don't think that we have much to fear in terms of some mass corruption on the part of the court. Now, of course, the court can make a mistake. Now, I'm not saying the court can't make a mistake. And I think one of the things we have to bear in mind is that when the court makes a mistake, they have made a mistake as far as we are concerned. And therefore, that is the role that the Faculty of Law plays and other such institutions in pointing out what we think are mistakes, if there are any, that the court has made. But don't for 1 minute think that the Privy Council has made no mistakes either. All the courts make mistakes, and that is what we are here for, both in terms of academics and in terms of our population. So I think the procedures in place are very, very well thought out to make sure that we don't have any possibility for the kind of mass corruption that I think you refer to.
But I thought that when you began by speaking of confidence, I thought you were going in another direction. But it seems to me that you ultimately saying, why should you have confidence in the Caribbean Court of Justice? Am I getting you correctly? Because I thought initially what you were really saying, the lack of confidence in ourselves as a people. I thought this is what you were actually saying. But you're actually saying you have a problem, it seems to me, with the confidence in the Caribbean Court of Justice when you ended by saying it's too important, so we need to get it right. Have you got it right that you have the Privy Council? In other words, what is this confidence that we are talking about? Is it confidence in the competence of the people, of the judges? Right, so therefore, because it cannot be that. Because if you know anything about me, you know how devastating my criticisms of the Privy Council's decisions have been in our cases. I think the Privy Council is not that good a body. But that's separate and apart from it. What I'm saying is this, is that I cannot understand this question of confidence in the sense that, notwithstanding what Professor Anderson is saying about we could have Privy Council judges, I hope we never have any Privy Council judges on the Caribbean Court of Appeal. We have sufficient, abundant competence in the region for us to people our own court. And I want to know, where is this lack of confidence? It has to be, in the fundamental sense, a lack of confidence in ourselves as a sovereign people. Hence the reason why we are holding on to other people's institutions and not realizing that those institutions are not ours. Yes. Yes, but look at the example that, yes, but look at the example that you've drawn. You've drawn a political example in which you are saying our political practices have not matured essentially in the way, I think that's what you're saying, as it was in the case of Britain. That is not a problem for a court, unless it's a matter, the court is not that kind of institution. The court cannot go out and simply say, you should not have exposed this document, therefore resign. The court acts only when a matter is brought to it. Only when a matter is brought to it. So therefore you are speaking, if that is the example that you're using, you're going back to my point. You're speaking of a lack of confidence in ourselves as a people. That is the problem.
Okay, maybe question shortly. Huh?
Yeah, you did cut me off the last time? I can't remember. Oh, that means you have intention to cut me off. Yes, I never know you cut me off the last time. So if you don't want me to talk, tell me, you know. Anyhow, greetings. You lose my focus, eh? Let me first of all say, good presentation by both speakers. Congratulations. But as usual, very intellectual, academic, and professional. which I applaud. For me, the issue is how practical and approached. Professor McIntosh in particular has expressed you are very passionate about this issue. But I am seeing some contradiction, and I think it lies with the approach. First of all, despite we have a low turnout here, some of our very important discussions such as this, they are too heavily loaded. In other words, we have lengthy reading and then very little interaction. And if I am to base my comment on what you have said in your presentation, the Grenada Constitution in particular, it lacked the communal authorship. In other words, never had the local input. So here we are talking about the input of the local people. And an issue such as this need to have a broad cross-section input of the population. And I'm not seeing that. In other words, if you can approach the political directorate to ensure and civil society that we have the mass population understand the issue. The other point I want to make in reference with your presentation, which to me kind of contradictory, is that you said that the Privy Council seems to be the last thing we need to address.
Seems to be the what?
The last issue to be addressed in terms of having full independence. Now, the Constitution came, well, if I am inaccurate, you just make it clear. The Constitution came as a package. And if the Constitution was not based from the input of the local people, then everything in that package has to be rejected. And your presentation has been passionate about only the CCJ vis-a-vis the Privy Council. So I am saying, by addressing the Privy Council does not mean that everything is okay. So I'd like to get that clear from you. Finally, Professor Stephen Anderson, two issues in terms of justice which you made in your presentation. And I think you have answered the concern of mine when most of the persons raise it. But in terms of having to repeal the Privy Council and to accept the CCJ, it is interesting for me that you somewhat separated the legal requirements. You focused on abolishing the Privy Council based on having the majority of Parliament. And then went on to add to that for the acceptance of the CCJ in terms of having the referendum, the general acceptance of the people. My point of interest and for clarification is to why make the difference? What is the basis for this difference? I don't really understand, because in my opinion, to abolish it, the Privy Council, to accept the CCJ, to me, basically the same requirement. And my question to you will again tie back to my concern about Brother McIntosh. If we are to have the CCJ, which he so passionately promote, I am saying we need to have it, put it in the hands of the people. We did not get the Constitution by the people, it was foreign, and so if we have to review the Constitution, if we have to add, we need to have people's participation. Thank you.
I find, wait just a second. I find your response amazing, because you were here when I delivered the paper on constitution reform. Then how come could you say what you've said about country? I came here this time to speak specifically about the CCJ. But you see how I've linked it with just a second. You spoke and I'm speaking now. You see how I've linked it with the issue of constitution reform. So I do not understand what you're saying about it has to come from the people. Yes, it has to come from the people, and that is exactly the point. What I'm doing here, without apology, is to make a philosophical justification for the court. That's what I want to do here tonight. So that my mission specifically tonight, even though it's linked to constitutional reform, is not a mass. I'm engaging the mass of the people directly, in the sense that I'm going out there to speak to them. They would get the message. Just a second. They would get the message if they've listened to the thing. What I'm therefore saying is that I do not understand that contradiction that you're speaking about. I simply do not understand. It doesn't make any sense to me.
Yeah, could I just respond to the question you directed to me? And basically, I agree with you. I agree that in order to accept the CCJ, you must, of course, involve the people in a referendum. There are some countries where you can accept the CCJ without a referendum. In Grenada, you cannot. You must have a referendum in order to accept the appellate jurisdiction of the CCJ. So that sooner or later, this process of a conversation with the people of Grenada must take place. And I think that's a very, 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 very good thing. I was just saying, however, that logically speaking, there are two different things. Because in the first instance, you could simply abolish appeals to the Privy Council and not accept the CCJ at all. And if you did that, then all that would be required would be the 2/3 in the House of Representatives. This, of course, is what happened in 1986, right? So logically speaking, there are two different things. But if the objective is to accept the CCJ, then of course people must be involved in a referendum.
Last question.
Thank you very much, Mr. Chairman. My name is Thomas Welch. Personally, I'm really amazed that we as a Caribbean people are still struggling with issues that concern our independence. In my judgment, a Caribbean Court of Justice is absolutely necessary. Else we are just talking independence at the top of our heads. But I think one of the reasons we are facing the struggle is that we have been seeking to change the Caribbean, particularly by legal means, without having a commensurate educational program. We need to produce democratic citizens, people who understand how democracy functions. In our own society, we still want to kill people over political parties and curse off people over political parties. We are still struggling with the fact that people have a democratic right to support whatever party they want to support. And yet we can still be citizens and work together for the building of the country. And it would seem to me that we have, together with the legal processes, which legal minds admittedly think about, there needs to be some kind of movement where there is commensurate education. Now, our colonial masters were very excellent at that. We had to learn civics. And we were taught how to obey the Queen and how to obey everybody and salute the Governor General and stand in the hot sun and sing Rule Britannia. But we have not yet in the Caribbean developed an educational system to create democratic citizens who understand how a democracy functions and who have the confidence that we can carry out our own government. And it would seem to me that with all the legal processes going on, we need to seek to establish a proper educational system to create democratic citizens.
Excellent point. Excellent point. And that is not a criticism of the CCJ. Excellent point.
We have come to the summing up, and I think it is fitting that you should give these two professors a strong round of applause. But if you may permit me, I didn't want to say anything, but I think I should. The issue was discussed as regards to the political interference. And some of us forget certain things. If you recall the previous U.S. election, when Bush was elected for the first time against Dole. And virtually, Bush was given the election by the U.S. Supreme Court. And most of those judges were Republicans. Those were the time with the hanging chads and so forth and whatnot go through. No judge gets on the court unless he's appointed by the President of the United States. Britain, most of the judges are from the upper classes. The Lord Chancellor, the man who sits in the Woolsack, is a member of the House of Lords. He's a judicial officer. And he sits in the executive, the upper house, and the House of Lords, and he administers justice, as the case may be. And they are appointed by the Queen by virtue of the recommendations of the Prime Minister. Canada is the same thing. Right now, here the United States talking, what kind of judge would Obama appoint? Meaning, what kind of judge will carry out the political will the president wants? And here we complaining about...
A president does not appoint a judge to the Supreme Court. a president nominates a judge, the Senate has a critical role to play in that appointment. We have seen those cases where the president's nomination did not pass the Senate. So therefore, that is not to say that the process is perfect. That is not to say that. The process is flawed. But let me say this. I don't know why we're talking about this. One of the worst judicial decisions in history, in my opinion, is the U.S. Supreme Court decision issued by Chief Justice Taney in the case of Dred Scott versus Stanford. The case in which he decided that this man who was first a slave and would have gone into a territory that abolished slavery and therefore was supposed to be a free man, but then was caught and returned to his master, in which he decided that this man was suing in the United States court under the doctrine of diversity jurisdiction. This man said, Taney said, that a descendant of the Negro race is not a complete person and therefore could not have jurisdiction to sue, is less than a human being. That is the worst decision. And guess what? Guess what? Then came President Lincoln. And President Lincoln, recognizing that the U.S. in their Constitution had made a fundamental blunder in that they preserved that institution of slavery in order to get the southern states to vote for the Constitution. The point is, he said that this has to be written out of this Constitution. But guess what? Guess what? That Constitution, and this is one of the reasons I'm unapologetic about my liking for that Constitution, because it's one of them. That Constitution is self-correcting. The Constitution is on the strength of that Constitution that slavery was abolished, that the 14th Amendment was then passed for equal citizenship, and the 15th Amendment. Those constitutional amendments could not have taken place in the South African apartheid constitution. That constitution had to be destroyed. The US Constitution has now continued for over 200 years because of the quality of that constitution. Slavery was in conflict with the Constitution. So there you have it. These constitutions were imperfect, they were bad in some way, but there is something exceptional about the US Constitution. It was able to correct itself. Martin Luther King never disparaged the US Constitution. Instead, he venerated the US Constitution. He said, if the people of the United States would only live up to the ideals articulated in that Constitution, then you would have something better. So therefore, listen.
We are on the same side. All I was saying, there's some political...
The false all around. In the French... Huh? So, I mean, I've had enough.
There's some political input in the U.S. for the president, in appointing presidents. We as a people, you see, we have this deep psychosis, colonial psychosis, that we don't even trust ourselves. And that's the hesitancy. Anything takes time to develop. There's an evolutionary stage. And we must complete the process. And we don't seem to trust each other. We never trust each other when we start the university. Let me say a point before we move to the thanks. I write on some thoughts which came to me, and I want to say this. We must remember that great achievements are not born from any single vision, but from the combination of many distinctive viewpoints. For our diversity as a people, challenge all the assumptions we make. I must remember that open minds can unlock our potential to solve any problem we as a people may face in this situation. Ladies and gentlemen, this is my contribution to the thing this evening. We come to the last item on the list, and that's the vote of thanks. But the lady who had to give the vote of thanks, she lives in Grenville, and she had car trouble. I had asked Mr. Ferguson, but he said he's enjoying sitting with his wife, so I will have to do it. A function like this cannot happen without the contribution of a lot of different people and personalities. We must first thank both Dr. Professor Anderson and McIntosh for consenting to come here. What we didn't say tonight, really, this is part of the process of sensitizing the region. Most of you have alluded to that. Sensitize government officials and our people as we got to the process. This is the second in a series. They started off in Belize about 3 weeks ago, and they're going through the rest of the CARICOM country in terms of dealing. dealing with this issue. And as we know, Barbados and Guyana initially accepted the CCJ in its appellate jurisdiction. And Premier Dean Barrow at Belize has gone on record as saying, as of December this year, Belize will no longer have any appeals forwarded to the Privy Council. Also, Prime Minister Roosevelt Scott of the Commonwealth of Dominica has also gone on record and hope by the end of this year too, the CCJ will become the final appellate jurisdiction for the Commonwealth of Dominica. And this is a progressive thing that we're doing. So I think everybody have alluded to the fact and said the fact that the people should be involved. It should be people-driven in the process, because a democracy thrives on an enlightened populace. And for this to take root, the people must have an input in this. And this is the process they are embarking upon. And we must be grateful and thankful for them for volunteering their services. They came here at their own expenses, ladies and gentlemen. So we must. In addition to this, we must be grateful to my friend who has been around with me in the last couple of days and early mornings, Professor Dr. Curtis McIntosh, who's a Curtis Jacobs. I like Teddy. There is a Curtis McIntosh. He knows that. Okay, that's McIntosh. No, he has a cousin named Curtis McIntosh, Dr. Thing. Head of campus, UWI, in the open campus in Grenada. And these are the facilities that we are using here. And it's a collaborative effort with the university, which has been spreading its tentacles after 61 years, and you see the contribution. Grenada, I understand, is about to become the 4th largest campus in the UWI complex. They are building a facility. I think Dr. Jacobs have just gotten the land to have an open campus built in Grenada in the next year or two, in that matter. So I want to thank UWI, Dr. Jacobs in particular, his wife for permitting him the last couple of days to leave the house at 6 or 7 in the morning to appear on GIS and MTV, in the TV station. We're also grateful to you, the public, for being here. I'm grateful for all the TV stations who has publicized it, for GIS for taping the show this evening. We're grateful too to the technicians that are here to help us in the situation. And most of all, we are grateful to you, the public, for coming. As small as it is, things start, big events. As the Chinese say, the longest journey begins with the first step. Thank you all for being here. Thanks for everybody. And we start the process again.